Welcome back to Law News Network. I'm Heather Hansen, and I am so excited that we have Sam Braverman with us. He has been a frequent guest, and we haven't seen him for a while. Welcome, Sam. He's a criminal defense attorney here in the city. Welcome, Sam.
Great to be back, Heather.
So good to have you, and so good to get your insight. I was picking your brain a little bit before we came on air, because I think it's a little bit, in my experience, a little bit unusual to have a witness called by the prosecutor, cross-examined, and yet called again during the defense case in chief. So you've actually been in that situation, so I would love for you to explain that to me and to the audience.
Sure, there are plenty of times that a witness might have some information that myself as a defense attorney, it's helpful to me. They did some line of investigation, they know some fact about my client, and I want to introduce that. They're not my witness. So even though I could lead them in the direction that I want them to go, sometimes I have to go beyond the scope of the direct. And a prosecutor may say, I object. A judge may say, you're beyond the scope of the direct, and it doesn't go to credibility. So at that point, normally what I would do is I'd tell the judge, I'm willing to adopt this witness as my own. That means that now that I'm calling them, the prosecution gets to cross-examine their own witness, because now they're on cross of my direct testimony, and I'm stuck with non-leading questions.
Right.
So that's generally the common sort of thing. Officer Jones went off in a particular direction. I want to investigate that in front of the jury, and I bring that out. Sometimes, however, and I've only done it 2 or 3 times, the judge will say, or a prosecutor will say, I don't want to interrupt my case with Braverman's, fishing expedition. So the judge will say, all right, Braverman, you can call this witness. The witness will be held in advance and will be called on your case. So then the witness comes back. I now stand in front of the jury and say, I will call Officer Jones to the stand. Officer Jones comes back, sworn in again, and now it's exactly as if I started the whole thing. All direct, non-leading questions on the topics that I choose. And when I'm done, the prosecutor can cross-examine just as if the roles were reversed. So the upside is you get your testimony. The downside is prosecutors often can cross a witness with the documents they have to your great disadvantage.
Yeah, and it certainly does make it more difficult, I would think, for the attorney to sort of keep it straight. What am I allowed to lead? Am I not allowed to lead? What did he say before? How can I use that to better further my case, since I'm now calling him as my witness? It certainly seems like it's a lot of extra work from the attorney.
Oh, I think that it is, and it is complicated that way. It is confusing to the jury,
right,
because they've seen me lead witnesses now for a whole trial,
yeah,
and all of a sudden I've got to do something different. Prosecutors love to lead, and like they always lead on redirect. After they've seen me leading for whatever
right,
it is, they
right,
come back and they're now leading their witness, and he said, no, I get to do that. You don't.
right.
Now it's reversed.
Let's talk
So
a
it's
little bit.
complicated.
Let's talk a little bit about leading. We talk about that as if everyone knows it, and I think most of our watchers are savvy trial watchers who know what leading is. But why do we use leading so much?
Leading is a matter of control. It's a question of who controls the narrative. So in direct examination, what you're looking to do is to impress the jury with the witness. And therefore, you're standing out of the view. Typically, I move the podium back so that the jurors are not watching me do the direct. I ask open questions that call for narrative. So the question is not just like, do you like hot dogs, but tell me, what kind of lunch meat do you really enjoy eating and why? And then the witness goes on a narrative. In cross-examination, you're doing the opposite. You are now controlling the courtroom. I move myself to the middle of the courtroom, so I'm the person directly in front of the jurors. I'm now talking to the witness, but I'm leading the witness where I want the witness to go. I'm asking questions that hopefully are tightly scripted. They generally call for a yes or no answer, unless I want and I don't know, unless I want them to choose between 2 choices they don't want to choose between. And so I'm telling the jury, I'm actually giving you the information you need to know. The witness is just either acceding to my request or fighting me. And if they're fighting me, even better.
Right. So it's really a huge opportunity, and one that you can't take when you're calling someone on direct examination. And it's one of the things that you see most often with younger lawyers, the objection that you see most often, because it's hard not to do it.
Oh, absolutely. Because you're so committed to your idea,
right,
that the idea that you should step back and let somebody else deliver your message is very hard.
Right, and as you said, it's a control thing. You want to, especially as a new attorney, you want to keep the story just the way that you planned it out on your piece of paper.
Exactly, and half the time you feel like you've got the wrong end of the tiger anyway.
That's right.
And you're trying trying to wrestle something to the ground from absolutely zero control.
Let me ask you, Sam, the fact that we've talked about this all of last week, we have this case where murder has been alleged, and not just murder, but capital murder. You've got a man facing the death penalty for the death of 2 young children, and it's a very sympathetic case, but no bodies. How does that impact the way that you defend this case, the way that the prosecutors approach the case, and the way the jury sees it?
Well, the hard part is that you need, generally speaking, in a no-body case, you need an alternative narrative. I mean, you always need a competing narrative of some sort. So here he needs a competing narrative that explains why there's no bodies. I tried a case a couple of years ago where there was no body, and I argued reasons why the person might still exist and be around there. One, we just had a very small piece of a body. We had a little piece of a skull about that big. And I made a joke about whether or not one could survive missing only that much, but still be out there. You're kind of stuck. At the same time, you have to act in every way as if it's totally normal that this person has gone missing. So somebody who lives off the grid, in this case, if a bad guy's killing a bad guy, the other bad guy might be off the grid anyway.
Right.
So he could go missing. 9-year-olds and 8-year-olds don't go missing. They've been kidnapped, or they are floating on the street, or they're not. But if they're not on the street floaters, why are they going to survive on the street? How have they not popped up somewhere on the grid when this is all over the news? So you have to have a narrative for that. If you don't have a narrative for that, and you don't want to argue that they are still alive, then you have to come in with somebody else killed them.
Right.
So you have the Jackson fellow here. Jackson comes on the stand and says, I don't know what you're talking about. Now, Jackson also, I think Jackson moved the car. Did he have some involvement in moving?
That's right. That's right.
Yeah, so you're kind of now, Jackson, it would be better if Jackson for the government said, I really have no idea what you're talking about. I've got nothing to do with any of this. But Jackson's involving himself a little bit, like he could be a co-conspirator or an accomplice of some sort. The water gets terribly muddied. I'm not sure that the muddying covers the defendant or the muddying makes the defendant more likely to be guilty, and the jury can say, look, it's the defendant or the defendant in Jackson. Either way, the defendant's on the hook.
What do you do in a situation like this, Sam, where you've got the defendant Toledo? He gave a number of interviews to the police, and so we've now seen, the jury has now seen the videos of 2 different interviews where there are inconsistencies that are starting to build up pretty badly. Now we're hearing, when we broke for lunch, we were hearing about a 3rd interview that was not videotaped but rather audio taped. When you have a situation like that, how many of those inconsistencies do you have to deal with? And how do you deal with them?
I think the question is whether or not in your narrative the inconsistencies are the kind of inconsistencies that any person might have. So, for instance, if I ask you to describe the books that are behind me, you'd say they're law books. But whether or not you know that they're New York state law books or they're New Jersey law books or federal law books, you might not notice and you might not care. And so in your description, you might say down the road, but because you're also a lawyer, you might describe them by something else. They're New York sup, they're Fed sup, there's something else that you would use anyway. So in his narrative, are these inconsistencies the kind of inconsistencies that anybody would make? Or the inconsistencies like, I killed my wife, I didn't kill my wife?
Right.
Those kind of inconsistencies you can't explain away. And now you have to have a narrative as to whether or not he was coerced into his confession or his confession is honest. And then you have to pick, in some sense, the best one you can live with. And the others, you have to term inconsistencies that are normal kind of inconsistencies. But at the deep level of whether you killed or didn't kill your spouse, you can't ride both.
We've talked about this so many times, and I know I've talked to you about this in various trials, Sam, but we've got a situation here now where the jury has heard from Toledo on 2 different occasions via video. The case does not seem to be going terribly well for him. What do you think about the possibility of him testifying? You think it's likely, unlikely, or yet to be determined?
I think yet to be determined. In some sense, the only person who really knows right now how well he would play is the defense lawyer. And I think in some sense that people are willing to believe what they see in real life over what they see in other factors. So if Toledo is the kind of guy who really could be a compelling, captivating, personable witness who could tell a good story, and he gets on the stand and he tells one story and it's totally coherent, it has a reason, it has a point, it has facts, it's tied to some other facts in the case, and then he can withstand cross-examination, this could be the case where it's most important that he testify. This may be the only thing that saves his life. Conversely, if he can't do those things, if on cross-examination he just starts lying again, he's finished.
Yeah. Do you think that the cross-examination or the examination of Jackson will be an important factor in making that decision?
It depends. I think at this point, the defense lawyer has got a good grasp on the skill set of the prosecutors.
Mm-hmm.
Whether or not they're the kind of people. I mean, I think when there's a lot of statements out there, the cross-examination of the defendant doesn't have to be aggressive. It can be just presenting the choices, and the defendant himself gets confused by which one to pick, and then just starts kind of roaming around on the stand. So you'll say, now in this particular case, you said this. Did the detective beat you into saying that? No. If he says yes, now he's just starting to take one lie to cover another lie. And eventually you'll get it so the jury will just write him off.
Yeah.
I think the defense lawyer would know whether another prosecutor is that type of prosecutor. The yelling at the guy type prosecutor might be the best thing for the defense if Toledo can stand up to that well.
Yeah, it's going to be interesting to see, because I get the sense that Toledo himself may want to testify. In some of these videos, he has seemed sort of overdramatic and almost acting. When you have a client who wants to testify, though you may think it's not the best thing, how do you resolve that type of tension? Or is it something that can't be resolved and sometimes you have to withdraw?
Well, let's put it this way. I particularly as you get closer and closer to trial, the stress on the defendant just keeps ramping up logarithmically every day,
right,
to the point that any defendant, defendants who are accused of the most serious crimes with the most serious prior criminal activities are still, nearly destroyed by the experience. It's exhausting, and particularly in a situation where a person literally could die at the end of the case. So it's very, very hard on people. So that's hard. It does mean, however, if you've built up a good relationship of trust with your client, so that your client, whether or not he agrees with you, trusts you on the most important decision, then you may still be able to persuade a client that it's a bad idea. So the trial I just did in September, I met with my client repeatedly as the trial was going. Each and every day, we sat around and we talked and we talked and we talked. So that whatever my recommendations were to him throughout the trial, he knew it was not some off-the-cuff experience. He knew that it was based on my 25 years of doing this and understanding who he is, and really being in his best interest. I think if Toledo's lawyer is with him throughout that process, he has a better chance to impress upon him whether it's a good idea to testify or not. That being said, there's some people who just insist, I'm going up. And you say, the defense now calls the defendant. And up he goes, and it's buckle up, let's see where this leads.
Oh my goodness.
It is, I have seen it as unbelievable a train wreck as it can be.
Yeah, I think our chatters are of the opinion that if Toledo does testify, it will be a train wreck. And so it will be interesting to see whether or not that happens. When you have a situation where a defendant has admitted to killing one person accidentally, but yet arguing against having killed the other, the children, how difficult is it to overcome with a jury that, yes, we killed that person, but we definitely didn't kill this person? Because we see that not only in this Toledo trial, but in the Willis case, which we expect to start back up tomorrow, another case where there's multiple murders involved in the allegations. How do you deal with that?
I had a case once where my guy on videotape confessed to killing somebody, shooting them in the head, wrapping them up in some chains, and dumping them in the East River in New York. And they fished up a body out of the Hudson River, New York. And for some viewers, you may say, well, how big a difference is that? Well, it's a difference. And so my opening statement at trial was, yes, my guy is a killer. Yes, he killed somebody, but that's not my body. My guy's body is in the East River, and this guy's out of the Hudson River. It's just the wrong body.
Wow, yeah,
The Navy divers came in to talk about buoyancy of bodies and how people float and die and decompose and all those other things. I asked him, did you actually search the East River at this particular location? He said, no, we haven't. I said, as you and I sit here today, fair to say that my guy's body that he killed could be that one in the East River? He said, fair to say. No further questions. And the jury acquitted. They were mad. I mean, they wanted to know when my guy was going to be prosecuted for the other body.
Right.
My guy was acquitted of that murder because there was a narrative that made sense. Here, the problem is that the mother and the children are presumably together. So how does your narrative work that I killed one but not the other? It has to fit into some understandable and tellable narrative. For the moment, I don't see that.
Well, and isn't that sort of the bottom line with all of these cases, Sam, is that both sides are telling a story, and ultimately it's up to the jury to decide which story is the most credible.
Absolutely. And that's the judge's instructions. It's first, what do you believe? It's the first role of the juror. What do you believe? Second, apply the law to what you believe. Third, your verdict comes from that.
Well, Sam, I can't thank you enough for being on with me today. It's always a pleasure to have you here, and especially in situations like this where you've got someone being recalled in the defense case. We appreciate your explanation. I appreciate you answering my questions.
Heather, anytime. It's absolutely my pleasure to join you.
We'll see you soon.
See you around court.